Good morning. Today is Thursday, June 19th, 2025, and welcome to today's regular meeting of the California Fair Political Practices Commission. Ms. Vo, will you please take roll?
Commissioner Brandt?
Here.
Commissioner Wilson?
Here.
Chair Silver?
Here. Okay, great. Let's move on to item number one, and that's going to be public comment for items not on today's agenda. It looks like we have public comment in the room. Please go ahead.
Hi, my name is Lori Alderman, and I've been a resident of Cotati for the city of Cotati for over 50 years. I'm usually on Zoom, but George dragged me down here now. What we need is we need help now, not 2 to 3 years when you get through the process. Our situation is so complicated with multiple people, attorneys, city officials, and the city council, all working in unison to deprive people of fair elections, fair civil rights, and the city goes after people's livelihoods, like with George Barrage. It was showed that according to a whistleblower, they wanted to fine him $250,000 for his code violations beforehand. They had secret meetings and all this with city manager, everybody, and the violations are bogus. And now the administration, the hearing's been going on for 2 years. We can't wait 2 to 3 years for you guys to get to it. And it's so complicated, and there's so many people. With me, I threw them a curveball. I'm on disability and have no business or assets for the city to go after. That doesn't mean they don't try to go after to get me too, because I don't sing kumbaya to them with them. I've applied to be on the city council, and then I got a city council member stalking me, cyber stalking me, and that I had to leave for personal reasons. This is the kind of tactics they use in city of Cotati. City staff, attorneys, and council members collude against anyone challenging unanimous ways, keeping any opposition at bay for financial reasons. They'll do things like the tax, add on 1% tax. The whole fundraising committee was city staff and council members. Not a single citizen paid a cent into the for Measure S in 2020 because they run everything. We don't have fair elections at all. Everything is decided beforehand, and they'll use any tactics to do it. And also, like the code enforcement attorney, Robert Smith, we tried to do a complaint against him on his Form 700s. He was able to manipulate your system by calling it a clerical error and got the case closed. And he's has multiple cities in Sonoma County that he works for. And he has multiple different assets. He puts different assets on his Form 700s. It's really complicated, and we don't fit into the what a form is, because most of the time it's just for one individual. So we just need help. Thank you.
Well, thank you, and thank you so much for coming down here today. I know it's not easy to come all the way here from Sonoma County, let alone, get in front of a group of people who are essentially strangers to you and be put in this position. So thank you for this and for all you're doing in your community.
Thank you.
And it's my understanding you were having trouble finding Form 700s with the jurisdiction around you. And that's something that I believe we took seriously, and we reached out to the jurisdiction and we addressed that issue. So I want you to be confident that if you're gonna come here, you're gonna tell us that there's an issue, if we're able to step in as the commission, we're going to take your concerns seriously and act when we can.
Thank you.
Thank you so much. Do we have additional comment? Thank you. Go ahead. Good morning.
Good morning. My name is George Barrich. I'm a former city council member in the city of Cotati. I've been before you before. Pleasure to be here again today. Two issues I'd like to speak of. The first one regarding the case that you just cited, Mr. Silver, against Mr. Smith. The last few numbers here are 00948. I understand, I wasn't the complainant here, but I understand that the case has been closed. And what I'm concerned about is that the 700 forms that were filed by Mr. Robert Smith in different cities, given his capacity as chief code enforcement officer and attorney in those offices, he claims as his excuse a clerical error by the city clerk. And I find that that's not a good excuse. For him to blame city clerks for his own error, we are all responsible as candidates for how we file. And I just feel he's been given special treatment here, and I'd like you to take a second look at this. We've looked at these forms, and there were blatant errors and omissions on those forms that any first-year law school student should be able to fill out. I think he's deceived the commission with those forms, and I'll tell you, 15 years ago, I was cited by the FPPC for not closing a campaign checking account properly. It had $13 in it. Lucky 13, right? And, after paying a $7,500 fine, plus my attorney $5,000, plus thousands of dollars of me taking time off of work, it was a travesty to get caught up in this. I wasn't able to throw my city clerk under the bus because she says, well, you're supposed to close an account, open another account, but I don't see anything wrong with it. I wasn't able to give him that luxury to say it was her fault. I had to take it. Now Mr. Smith gets to claim clerical error and you guys close the case. That's not right. The second issue is Miss Alderman is absolutely right. Your form for filing a complaint does not suffice for the type of racket and conspiracy that we're seeing, and we need your help. We need an investigator in your office to help us through this process. We're lay people on how to file such a complicated case. Okay, number two, I want to leave with you both for the clerk to make copies for you. Sworn declarations from Braden Eggert, who's a former Cotati code enforcement officer, explaining the depth of the corruption that he witnessed. You need to read this so that we can get assistance on how to proceed. It's a huge issue. It's going to get blown wide open. You are the state agency, we believe, along with the Sonoma County Grand Jury. But we are so proud that you are here for us and will give us the assistance we need on how to proceed. Okay, thank you.
Thank you again. And if you do have suggestions for changing our complaint process or tools online, please let us know. Please share that with the Enforcement Division. Do we have any other public comment for items not on today's agenda? Go ahead, sir. Good morning.
Good morning. I'd like to read you a couple of code sections from the Brown Act, 54954.3C. The legislative body of a local agency shall not prohibit public criticism of the policies, procedures, programs, or services of the agency or of the acts or omissions of the legislative body. And the legislative body includes your staff. From the Bagley-Keene Act, 11125.7D, the state body shall not prohibit public criticism of policies, programs, or services of the state body or of the acts or omissions of the state body. What occurred at your March 20th, 2025 meeting was an attempt to stifle public criticism of your staff's policies and programs, which at this point seem essentially ineffective and worthless. I'm telling you that there is a disconnect between you on this board and your legal staff due to the fact that cases which should be prosecuted are allowed to fall by the wayside because of your prosecutors, and you never see them or are aware of them unless somebody like me attends and tells you. In addition, you don't want to take input on these board meetings because it will prejudice your decision making. The input is necessary so that you may give direction to staff so that you may understand any specific case rather than having it quashed by those who should not be making these decisions. I have attempted to use logic with minimal emotion while remaining professional and purveying to the entire body of the FPPC, the Commission, the flaws within your system of dealing with what I view as the local and state swamp, reflective of what we see in Washington, D.C. The March 20th meeting was typical of those protecting their staff rather than considering the validity of the accusations. It seems, as is typical of my conduct and approach, I managed to strike a raw nerve or push your appropriate button. As you conveyed to me in our initial conversation, that means you, Mr. Silver, the reason you supposedly are up here doing this job is you viewed corruption up close and personally in the LA arena. When I point out what I feel is corruption or ineptitude of your legal team, you evidently are refusing to examine the basis of my complaint and prefer to defend the indefensible. Both you and Mr. Wilson simply and adamantly stating that your staff works hard belies or adequately demonstrates a disconnect between demanding physical labor, not of demanding it, but demanding physical, and that of basic research and paper pushing. As I have worked both sides of this coin, I was long ago advised by a coworker that it's far better to work smarter, not harder. The facts speak for themselves. As I stated, your staff is more concerned with closing cases than prosecuting those who have gained financial benefit from the elected positions they hold. The meeting where your chief enforcement officer was bragging about the amount of cases he and his staff closed should have elicited the trust but verify approach touted by President Reagan. It is only common sense. How exactly were these cases closed and could their termination be justified? The only reason I am here today is to express my disappointment that no one is willing to address the flaws in the process or the system. You don't fix something that is not broken. When the process is the problem, you look for a solution. Government evidently is not the solution, but the problem. I had hoped to work with you rather than opposition to carry out the intent of this agency and the law. I will not be silenced. Thank you very much.
Thank you for your public comment and your input. Just to clarify, we are open to any sort of feedback or input on cases that are closed. The reason why we have concerns with hearing information related to ongoing cases is it can bias us as a quasi-judicial body. So just to clarify that one point. Do we have any other public comment for items not on today's agenda? No? Any other comments? Okay. Okay, we're gonna take a 2-minute or let's say a 5-minute break. Okay. Okay, let's move on to, let's wait for Executive Director West to join us. Okay, excellent. We're going to move on to item number 2, and that's going to be approval of our May 2025 minutes. Commissioners, any comments or suggestions related to those minutes? No? Do we have any public comment related to the May 2025 minutes? Hearing and seeing none, we have a motion to approve.
So moved.
Second?
Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion passes.
Okay, let's move on to our consent calendar, and that's going to include items 3 through 6. We're going to welcome our enforcement team up to the table. And that's going to be Assistant Chiefs Chris Burton and Angela Brereton. Good morning, Mr. Burton and Ms. Brereton.
Good morning, Chair and Commissioners.
Do commissioners wish to pull any items from the consent calendar?
No.
Okay. I agree. We don't plan to pull any items from the consent calendar. Any comments generally related to the consent calendar? The only comment I had is I, again, want to emphasize, especially in light of the public comment, what an excellent job the Enforcement Division did this month. We as a commission have directed you to focus on the most serious violations. And when I run through the consent calendar here, we're looking at misuse of campaign funds, conflicts of interest, and illegal gifts. These are the exact types of violations that the public is hoping that we're cracking down on. And job well done. So with that,
I think I will follow up on that in that
course.
case. Because I also want to say I appreciate the understanding the intent and some of the facts. On one of them, I thought, oh, a reporting violation, and then a violation of gift. I want to say I appreciated getting the sense of what really happened there and what the actions that were taken that show intent. And so that was helpful to me to convince me to say, I'm good with all this.
any public comment for items on the consent calendar? Okay, hearing and seeing none, I'm going to move to approve the consent calendar, items 3 through 6. Do I have a second?
Second.
Excellent. Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion passes.
Okay, let's move on to our pre-notice defaults, and those are going to be items 7 and 8. Let's start with 7, and that's going to be in the matter of committee to re-elect Michael Minix and Michael Minix individually, FPPC numbers 20817 and 2998.
Thank you. We haven't had any contact from Mr. Minix, so I don't have any other updates other than the summary that's in the agenda.
Okay, and what sort of contacts have we attempted to make with Mr. Minix?
Well, the usual, like reaching out, trying to get filings done, that kind of thing. But also, we've served a PC report by this point. We have served the accusation personally on all of the respondents. So, we've made numerous attempts to have some interaction and compliance, and this is the stage we're at because we haven't had engagement.
Okay, and is Mr. Minix, is he still in his office right now?
I apologize, I do not know that information off the top of my head.
No problem. Why don't we do this? If you wouldn't mind just taking a look at that point, maybe we can bring it up during executive staff reports.
Just a sec. He is still in office.
Okay, that's helpful.
Thank you. My question is, has he responded at all? Because I know he's received information based on the detailed work that, your team does.
My impression is that we have had some spotty interactions with Mr. Minix, but the ultimate cooperation hasn't been reached in that, in order for us to come to a resolution, we require that campaign statements be filed. We require that certain steps be made. And when we don't have that type of cooperation, we have to keep moving forward with our process. We also often will have situations where someone will be cooperative with us initially and start working with us, but then goes radio silent. So either of those situations lead to the result where we have to bring a default in order to close our case.
So it seems to me that he could not say that he did not receive proper notice because you've gone through all the steps that are required by law and by our own internal procedures, correct?
Correct, yeah, and we've served our probable cause report as required by the statute, and we've also personally served the accusation as required by our rules as well as the Administrative Procedures Act.
Okay, thank you.
Commissioner Brandt?
Couple questions. So if he's still in office, have we been in touch with where he serves?
We typically do not engage with the agency that the person serves with, though we have served people during meetings before. You know, that has been a way that we have effectuated the service requirements that we need. But as I said, we typically don't engage with the agency because the responsibility is on the office holder, candidate, committee, treasurer, those folks, not the agency itself.
I understand. And we haven't had any contact like saying, you know, well, I reject it or anything like that. I'm going to have nothing to do with you because this is wrong or something like that or anything like that. We don't have anything from him.
I can't respond to that kind of question. It's outside of the information that I can share.
Has anyone had any conversations with him? I'll say that.
I'm bringing up the attorney who's working on this matter. You can introduce
Good
yourself.
morning. My name is Laura Clumbell, and I am Commission Counsel for the Enforcement Division. I have not personally had contact with him. Our intake team initially did have the contact with him via email in the beginning of the process, and then after that, I have personally reached out multiple times via email, via phone call. He was personally served, but he has not reached out to me to have a conversation.
Hello, I'm going to interrupt right here. Galena West, Executive Director. Remember, everybody, this is pre-notice of defaults, so the information is not before you at this time. This is a notice that we have created to try to get people to come to the table for settlement. So all of these details may or may not come before you as a stipulation. So this is to get the notice out there and let him know, hey, this is your last shot. We don't want you to have to come back after a default and then ask for a motion to vacate. We're trying to put as much notice out there as possible. And the attorney assigned, Laura Klemble, she will be in contact with him and going through all of our procedures. So just reminding you that unfortunately, we don't get to tell you everything right now, but this is just something that we made up as a commission in order to try to get people to come to the table.
That's helpful. And at least where I'm coming from, where I assume fellow commissioners are coming from, is it's particularly frustrating when we have respondents go through this whole default process, and then as soon as they're issued their default fine, then the light goes off and they come to us asking for us to vacate that fine. So we're hoping that we are taking every appropriate step to make sure that they're aware of this matter and of their delinquency. So we appreciate you walking us through the procedural process related to that. Commissioner Wilson?
I can't speak for Commissioner Brandt, but I'm sensitive to the fact, and I think we're all sensitive to the fact of the countless hours that the FPPC team has put into this particular case, and that shouldn't be lost in the process. I mean, a lot of staff resources, a lot of time is expended, so that's obviously a factor that should be taken into account as we move forward. So, thank you.
That's an excellent point. Any public comment on this item? No? Any other comments from commissioners? Okay, well, we're not taking any action on this item, so we can move on to item number 8 in the matter of Brown for Bassett School Board Member 2024, and Samuel Brown, FPPC number 2024-1046. Any comments or questions from commissioners? Commissioner Brandt?
I did want to understand, when were these pre-election campaign statements? How far back are we talking?
2024.
Right,
These were
so-
related to last year's election.
So like in the fall, that kind of thing? So
Yes,
less than a
this
year.
case was related to the proactive pre-election outreach program, where our prep staff reaches out to filing officers, gets lists up from them of folks who haven't filed their pre-election statements, and our prep staff then reaches out, tries to get people to file. Occasionally, they're not successful, but most of the time they are. But the ones that are not successful get referred to the prosecution's team, and then we try to get them to comply as well. This is one of the few instances where we were unsuccessful. But I think we had 2 where we couldn't get them to file. So, it was a very successful program. So that's how we got this case, and that's why it's so close in time to when the activity occurred compared to today, bringing the pre-notice default.
Thank you. Any other comments from commissioners? Any public comment on this item? Hearing and seeing none, why don't we move on to our general items, starting with item number 9, and that's going to be Winuk opinion. And we're going to welcome to the table our Senior Commission Counsel, Kevin Cornwall. Good morning, Mr. Cornwall.
Good morning, Chair and Commissioners. So I'm here today to discuss the Palo Alto City Attorney's request for a commission opinion regarding Palo Alto City Manager Ed Shikata's responsibilities under the Political Reform Act. And I realize it was a pretty lengthy memorandum, so I'll do my best to keep my summary here succinct. So essentially, staff is seeking direction from the commission on 2 questions. The first question to potentially be addressed in a commission opinion is whether, for purposes of the Act's conflict of interest provisions, Stanford University should be treated as a source of income to Mr. Shikata based on his spouse's employment with Stanford Healthcare. And so just to emphasize, any commission opinion would be addressing these specific facts and not establishing any sort of general rule applying to all nonprofit relationships. The second question is more in line with that, and it would be addressed separately from the commission opinion, and it's whether the commission would like to take any next steps in a related regulatory process on this, addressing this issue. So to quickly summarize, in the Lee advice letter written more than 40 years ago, the FPPC advised that a public official whose spouse had a source of income interest in Stanford Hospital also had a source of income interest in Stanford University, based on the structure of the 2 organizations, which included the same group of persons with ultimate voting control over both entities. So essentially shared boards. More recently, in the Vani advice letter, the question arose on whether that advice essentially was still applicable in 2025, now that Stanford Healthcare's bylaws have changed, including that the 2 organizations now have largely different boards. In the Vani advice letter, we advised that Mr. Shikata had a source of income interest in Stanford University, citing various factors in Stanford Healthcare's bylaws, but most notably that Stanford University had the power to appoint and remove Stanford Healthcare board members. So the city attorney has requested a commission opinion reaching the opposite conclusion of the Vani advice letter, advising that Stanford University does not constitute a source of income for purposes of the Act's conflict provisions. And in reviewing the materials and researching the topic for the memorandum, the legal division doesn't think that there is persuasive reasoning for reaching a conclusion different from the Vani advice letter. But I'm happy to answer any questions the commission may have regarding those different approaches or conclusions. And then as I stated, we would be seeking direction from the commission on the commission opinion and any potential regulatory process that the commission might want to pursue. So I'm happy to answer any questions the commission may have.
Excellent. Well, thank you, Mr. Cornwall. You did an excellent job with this. It's a very complex topic. We're happy to have you here walking us through it. I also want to thank San Francisco Ethics Commission, the California Political Attorneys Association, for providing us with input on this item so we can make an informed decision. And lastly, I want to recognize the opinion requester, City of Palo Alto. They've requested advice formally on this topic several times. And that's exactly what we would hope a jurisdiction would do under these sorts of circumstances. So I think that's something to be recognized. With that in mind, I'm really hoping that we can come out of this discussion today with clear direction for City of Palo Alto, Stanford University, to a certain extent, as to how they can address this issue going forward. I'm interested in hearing from the requester's representative to the extent they plan to present, but I'd also, like to give fellow commissioners a chance to comment, ask any questions that they have before we go ahead and do that. Do we have any comments or questions?
I do, but I'd kind of like to hear the requesters, if they are here to speak or something like that. I'd like to hear them first before I go into questions.
Excellent. Well, they can come up.
Yes,
Mr. Winuk?
I do have lots of questions.
Good morning, Mr. Chair and Commission members. My name is Gary Winuk from the Kaufman Legal Group, here representing the City of Palo Alto, and Mr. Shikata, who is here present, and the Mark Vanny from the Vanny Advice Letter that you're considering is right here from the City Attorney's Office as well. I do want to raise some points, but they are also here if you have more detailed factual questions. They're also available to provide additional facts if you would like to. I also want to thank staff, Mr. Cornwall, for his work on this. As the chair mentioned, it is a complex issue and one that has now 40 plus years of history. So I appreciate the thoughtful analysis, even though we have a disagreement over what the result is, but I do appreciate their efforts and their analysis on it. So as Mr. Cornwall said, there really are two issues that I think are before you today. One is the individual determination of whether or not Stanford University and Stanford Healthcare should be considered affiliated entities as nonprofits. And currently that analysis, as you can see, is done on a fairly subjective basis, based on sort of piecing together rules from advice letters. Second, though, is also whether you want to take advantage of the opportunity you have before you today. This is an issue that comes up much. I've been working in the field for a long time, and I've never really given this issue specific thought. It hasn't really come up because nonprofit entities tend to be more separate, I think, than corporate structures, which have subsidies. So you do have an issue before you that I think is ripe for at least some discussion about how you want to proceed and how you want to advise the regulated community on how to comply with it. So I view it as an opportunity for you as well. First, I want to talk about the specific individual determination. And so as Mr. Cornwall said, the FPPC provided advice in the 80s on a very similar topic. Should Stanford and Stanford Healthcare be considered the same entity? And in those early advice letters, the FPPC did find that those are affiliated entities. The issue, though, and I think our main point of contention with the current advice letter is that much has changed since the 80s in terms of relationship between the two entities. And so under the old standard, under the old rules, there was a much greater degree of control and relationship between Stanford and Stanford Healthcare. So specifically, there was a single person, a vice president of Stanford University, who was also the president of Stanford Healthcare. So you had kind of a person serving those dual roles, exercising control over both entities. And then second, the healthcare board members were required to be Stanford board members as well. And so you had this sort of shared governance board that I think, even under the standard of regulation 18700.2 would still meet that definition. So under those old rules, I think I understood why the advice came down the way it did. But things have changed over time. The bylaws changed in terms of their relationship and have developed over the years. So those two factors I mentioned are no longer present. They don't share a common employee running one entity and serving as the vice president of another. And the healthcare district or the healthcare board members are not required to be Stanford board members anymore. So under the new bylaws, there's really three formal pieces of the relationship. First, Stanford's president has the ability to appoint board members and remove them for Stanford Healthcare. Second, Stanford has the ability to approve bylaw changes that are made by the Stanford Healthcare. And then third, the Stanford Health Corps is required to consult with the president of Stanford University on the selection of the hospital's president. So those are really the three things now that are still remaining. But in our opinion, that doesn't reach the level of direction and control to pierce through, if you will, one corporation to find another. The healthcare, Stanford Healthcare is a massive organization. Its board runs its finances, its hiring, all its policies, and all the operational things that are involved in running that district. Stanford University is not involved in those day-to-day issues and doesn't exercise that kind of direction and control. They're limited just to the three things I mentioned in terms of how they interrelate. And currently, in terms of the board members of Stanford Hospital and of Stanford University, only one of the 26 board members for Stanford Hospital is also a member of Stanford University. So there really certainly is a majority, but there's just a tiny percentage, if you will, of board members in common. Certainly not enough to have a majority exercising control over both. So for us, those factual changes show that the two entities should not be affiliated and that they should be considered separate entities. The other fact that I think I want to throw in is that this issue got litigated in another context in Alameda Superior Court. And I know there's a discussion of it in the staff's memo. And certainly, the issues aren't exactly the same between here and there. But a court did make a determination as to whether or not they should be considered the same entity in a different context and came to the conclusion that they shouldn't as well. So I think that's something that the commission can take under consideration, is that's an issue that's been litigated and decided by a judge to show that they're separate entities. So as Mr. Cornwall suggested, we are asking the commission to take specific action to find that there isn't an affiliation between those two entities in this specific case. Second issue, though, is also just sort of the opportunity to adopt the standard. As you can tell from the discussion that we're having here today and through the advice letters over the years, it's really a bit of a subjective standard currently. The FPPC has articulated some standards in some language in its advice letters, but really it's come down to a case-by-case determination. And that's really a difficult thing for the regulated community to have to apply. There's always that tension in the course of the FPP's history between a bright line rule, which may not encompass every situation the FPPC wants to, versus a subjective standard where you may be getting a more individual determination, but it's much harder for people to comply with. So there really is always that tension in a lot of what the FPPC does and considers on a policy basis. But our suggestion is that, excuse me, in this particular case, we recommend adopting a more bright line standard for a couple of reasons. One, there already is a bit of a bright line standard for for-profit corporations. And so there is not one for nonprofit corporations. So to us, it seems more consistent to apply similar rules to similar entities. And so there is a direction and control standard for for-profit corporations already in the regulations that's been obviously promulgated by the FPPC. So for consistency's sake, I think it would be helpful to have a similar type standard for nonprofit corporations. And so we recommend that the FPPC take some action to adopt a similar type standard in regulation to that. And really the key for the nonprofit standard in the regulation is sharing of board members or for single individual direction controls. So in our case here, we had, under the old rules of Stanford, you had a similar individual working at Stanford, and also being the president of Stanford Healthcare. And so that would have met that standard under the old advice letters because you had a similar person directing and controlling. Under the old standards, the 80 advice letters, the 1980s advice letters, they also shared a majority of board members. And that's the second factor under the current for-profit standard for 18700.2. So under the old standard, the old letters would have been consistent, but under the new standard, if that was applied to the current situation, Stanford University would not be considered, in my opinion, an affiliated entity or related entity to Stanford Healthcare. And so I think it's just important to have some clarity so people can have advice. And in my practice, I've learned most people want to comply with the act, but do face some challenges in trying to pour through advice letters and figure it all out. And the truth of the matter is, a lot of this comes up and comes at you fast when you're in local government. Mr. Shikata and the city of Palo Alto have a lot of interaction with Stanford University. And so these issues come up, they'll have an agenda item, and they really need an answer fast. And that could be difficult to get. As you can see, this has become, an important and thoughtful but drawn out process to try and get an answer. In the meantime, Mr. Shikata is, having to avoid dealing with important issues to the community, even as the city manager. So I think a clear standard is sort of the way to go here. We recommend it. I don't want to speak for CPAA, but CPAA has sent their letter in also saying that they support that. So we'd actually take a look at that. You can direct staff to come back with some options that you could consider and then make that decision as well. So basically just asking for two things. One, for clarification on this particular situation, and to find that Mr. Shikata does not have a financial interest in Stanford University, even though his wife works at Stanford Healthcare. And then two, just to direct staff to come back to you with some options for addressing the issue in the future. That's all I have. Thank you for your attention. Happy to answer any questions.
Thank you, Mr. Winuk. I think you make a persuasive argument, especially to the second item. As someone who's been in private practice, counseled entities and individuals on these laws, I think where we can, where it's workable, it's certainly ideal to have a roadmap for the regulated community to have to get to compliance. Because in my experience, like you, Mr. Winuk, the vast majority of actors in this space are attempting to comply with the rules. One thing that concerns me about adopting a general rule or regulation on the fly, and it sounds like you agree with this as well, is this is a very complex area of the law. So when we're talking about nonprofits, we're talking about 501c3s, so charitable organizations, C4s, C5s, labor unions, chambers of commerce. I'm very interested in hearing what their concerns would be, taking a closer look at how they're operated, their relationships with other entities, so we can better understand what type of standard, if any, could help us get to where we're trying to get to. With that said, I'm very interested to hear what fellow commissioners, Commissioner Brandt.
Okay, so I want to understand the analysis, so I need to kind of step back. So I want to hear from you, Mr. Cornwall. What changed and what didn't change between Lee and Bonnie? So what are the facts that, and this is for your analysis and your conclusion, what changed and what didn't change that kept you at the same conclusion? I mean, and there may be changes that contributed to, it's still a connection. So that's what I want to understand first, kind of the facts in your analysis. I mean, yeah, we see it on page 5 and 6, and I see those things, but I want to hear about your analysis of those. In other words, these are stated as the facts, and what was significant. That's what I'm trying to understand. What was significant in your reaching that conclusion of what changed and what didn't?
Yeah, so just to clarify, I didn't write the initial advice letter, but I do agree with its conclusions. So when we're analyzing this question, the question is basically a public official under the Act is generally disqualified from taking part in any governmental decision where that decision would have a reasonably foreseeable material financial effect on certain economic interests, which include a source of income. And so the act doesn't define that source of income specifically, and there isn't a statute or regulation that directly addresses the relationship between nonprofit organizations in the same way that Regulation 18700.2 does. And so historically, with Lee, Vonnie, and some of the somewhat similar advice letters, we've approached the question on a case-by-case basis to determine, should these related organizations be considered essentially one and the same source of income. And so in Lee, Mr. Winuk's correct that it was a more closely, more of an overlap in control of the two organizations. Most notably, the fact that it was the same board. So the people making the decisions, the day-to-day decisions in one, were making the day-to-day decisions in another. With the Vonnie advice letter, we see that the bylaws have changed somewhat. There are some instances in which Stanford University now gives guidelines or general direction to Stanford Healthcare. But with respect to the boards, they're generally different boards, but that Stanford University has control in terms of appointing and removing board members.
Okay, so that's what I want to drill down to.
Yeah.
So is it their control of appointment and they appoint at this point one board member? And is that right?
They appoint all board members.
Okay. So is that the significant fact? That's what I'm trying to get here, is that get to understand what the significant facts are in the analysis. I mean, you're still standing by Vonnie.
Yeah.
So I want to, I mean, even though you may not have written it, I still want to understand what convinces you to say there is a connection here. There is enough to pierce the corporate veil. We'll get to that question, legal question, in a minute.
So I think that that's probably the most notable and persuasive fact about the current bylaws is the power to appoint and remove the Stanford Healthcare Board. I think that some of the other facts that are persuasive is the fact that Stanford can amend the bylaws, or Stanford University can amend the Stanford Healthcare bylaws at any time, that they're the sole member of the Stanford Healthcare Corporation. Stanford Healthcare meetings this is coming from the bylaws provided as an attachment with the initial request. Stanford Healthcare meetings can be called by Stanford. They establish guidelines for Stanford Healthcare budgets. They adopt limiting resolutions for Stanford Healthcare contracts. Stanford consults with Stanford Healthcare on conflict of interest policies. Stanford Healthcare provides periodic financial and strategic planning reports to Stanford. They provide annual audited financial statements and quarterly financial reports to Stanford University. So, I mean, there are more factors, but I think I think that the difference is that whereas Mr. Winuk is emphasizing that maybe the day-to-day decisions or lower level decisions or day-to-day decisions regarding Stanford Healthcare are made by the Stanford Healthcare Board, which differs from Stanford University. Stanford Healthcare or Stanford University is still in ultimate control of Stanford Healthcare.
Control.
Yeah.
So is that the key issue? Because is it significant that that the Stanford Healthcare reports, gives reports and provides information to Stanford? Is that significant?
I mean, I think I think if we were, and I know we discussed Regulation 18700.2, and I recognize that it specifically applies, that regulation applies to for-profit corporations. But if we're analogizing, I think that you can kind of look at Stanford University as having 100% of the voting shares in terms of this corporation, where maybe they're not making the Stanford Healthcare Board, decisions, but they have the power to appoint the board, and in doing so, they essentially control Stanford Healthcare.
Okay, so control, and I also want to understand the I think you lead to piercing the corporate veil. In other words, analogizing to for-profits and those kinds of things. And so I want to understand, how do you treat for-profits? I mean, yes, I know there's a regulation, but and that is significant. But how do you treat? Are there different ways? Are there different things for nonprofits? Are there different things that we should consider as being the significant points about control of relationships between nonprofits?
Yeah, I mean, I think that highlights something that's been touched on, is that the complexity it's perhaps more complex, the relationships between nonprofit organizations as compared to business entities. So in other advice letters that we cite in the memorandum, there have been different factors that the FPPC has considered on a case-by-case basis in terms of control of budget or shared resources and assets. So I think that there are various criteria, and that sort of highlights the difficulty with potentially pursuing a regulation, is that I don't know how feasible it would be to come up with a bright line rule in terms of this is when two nonprofits should or shouldn't be considered the one and the same, is that there are so many differences between nonprofit organizations, and a lack of consistency between relationships, that it might not be feasible to come up with just a narrow, this is the bright line. That a regulation might have to take more of a these are particular criteria that we think are relevant, and maybe a non-exhaustive list. But I think that kind of highlights the difficulty with the regulation.
Is there a difference between 501c3s and 501, I think it's C6, business or business associations, that kind of thing? Is there a difference when you're looking at nonprofits between those kinds of organizations? In other words, one's doing charitable, educational, those kinds of things. And well, let's start there.
Yeah, to be honest, I haven't researched like the distinction in C3s and C6s in this context, just because it was sort of outside the scope of the specific question involving Mr. Shikata. But if the commission was to direct us to research and potentially come back with a regulation, that would be something we would look into.
Okay.
So Commissioner Brandt, if I could step in with clarifying question, kind of step back. What we're looking at today is whether or not Mr. Shikata has an economic interest in Stanford University vis-a-vis his spouse's income from Stanford Healthcare. And the question is, do we consider those essentially one and the same for purposes of the act? Would that further the act's purposes, right? In terms of conflict interest principles.
Right.
Public officials cannot have two masters.
Yes.
Or three in this case, potentially.
Yeah.
Right. So what do we look to? It looks like in the corporate for-profit, I should say for-profit context, because nonprofits certainly can be corporations, we're looking to direction and control. And there are certain criteria that have been laid out as to when that exists. Personally, myself, and I'm interested to hear from fellow commissioners what their take is on this. I actually think that the elements, criteria set forth in 18700.2 may be too strict, right? So pull up the reg. So I'm looking at 18700.2, and it lays out that a parent, in the case of a for-profit, a business entity is a parent, quote unquote, if it is a corporation that controls more than 50% of the voting stock of another corporation. The reason why presumably the commission specified voting stock in that case is because the aspect of control that voting stock comes with, right? It allows the shareholder to be able to vote on very important things, including who is on the board. So if I was going to extrapolate this regulation to the nonprofit context, I would say that a corporation is a parent, or a nonprofit, I should say, is a parent if it can appoint a majority like this, more than 50% of the board of another nonprofit. I think in this specific case, and we're not talking generally across the board, that that's not in of itself sufficient to find that relationship between the two where they're one and the same, and the related entity is considered a economic interest to the public official. What concerns me, and this again goes back to this aspect of direction and control, is does a third party have the ability to exert significant influence over decision making, right? And I believe that if a third party has the ability to remove board members, the individuals who are in charge of decision making, then at the very least, there's the appearance that that third party has significant influence over decision making. I'm interested if commissioners have thoughts on that specific point. Commissioner Wilson?
I just want to, Ms. Cornwall, just for clarification, and I think it was clearly outlined, but we've been talking about the ability or the authority of Stanford University to remove board members. But you also stated, correct me if I'm wrong, that they also have the authority to appoint members.
Yes.
So in theory, and I'm not saying this would be the case, they could remove 10 members tomorrow and then appoint 10 new members. Is there any action that the hospital board could take to address such an issue, or the bylaw is so clear that that authority that Stanford has is unilateral in nature?
So the note that I have is that they can, elected directors elected by the, Stanford board, can be removed at any time without cause by vote of Stanford University. So it's my understanding of it is that it's essentially under their complete control.
Okay, thank you.
Sorry. So I want to kind of follow up on both of those things. So I can understand how if you're controlling the board, that's a line. And part of this is I'm also thinking about the long term, not just Stanford. And I could see that if you give up that control of the board, then I could see that being a clear and bright line in some ways. I mean, that's one. But then I would kind of want to, and maybe this is not today, but in thinking about if we're going to give direction on rulemaking or other kinds of things, I work in nonprofits. I've worked in nonprofits. I've been general counsel of a nonprofit. And these days, there are so many relationships. Two things. One is, in the last 30 years, nonprofits, governments have given up kind of, or not given, contracted out to nonprofits to do a whole lot of government work. And in some ways, it's there's the exemption for governments where the nonprofit is like a government. I mean, especially 501c3s, where they are doing the government's work that government used to do. So that's one piece of it. So there's the government issue. Then there's the other collaboration issue, where the nature of nonprofits, and I think in some ways it goes to, yes, the board is the big issue, and that's the control and of the board is the big issue. And maybe that's enough. My concern is that do we get to a place where we start looking at these relationships? Because my nonprofit now, there are times where we're directed by we're contracted to do something, or we actually accept direction from others. Sometimes it's a nonprofit made up of government officials, that there may be things that say, we need you to do this, do that, and that kind of thing. And we accept that direction. It may not, and there's relationships, and there's contracts, and there's agreements about who gets to say what. And it is hugely complex. And so I guess no. And so in some ways, I feel like it could be really comfortable to just talk about the boards And that's really the decision, and whether they have control. You know, and you're talking about the majority voting control. Is majority, I don't have an answer for this, but is that if they can appoint or they can withdraw a majority or the entire board, if that's true, then I can see that connection and I can see that kind of relationship. But if they don't, if it's just one board member that they have control over, then I'm not as concerned about that. But if they have control over the entire board and being able to withdraw or, appoint them, and are they also required to be nominated? I saw some reference to that. Is that still true?
I believe my understanding is that one Stanford University board is in charge of nominating and another Stanford University board is in charge of electing.
Okay. Huh. So you can't get on the board of Stanford Healthcare unless Stanford says, yeah, that's the person we want. Is that right?
Let's see. The Stanford's Committee on Trusteeship nominates, and Stanford's Board of Trustees elects Stanford Healthcare board members.
Okay.
And
So,
just to sort of clarify a couple of things, I think with respect to like the government issues and accepting direction, like in the context of a contract, I don't think that that's what historically like the FPPC has found as persuasive of a relationship that we would consider two organizations one and the same. I think we cite the GINA advice letter on page 9, and essentially that's two local unions that are distinct nonprofit entities, where we said that an official doesn't have an interest in one of them based on their interest in the other. And in that letter, we discussed that there's no crossover, for example, in funding or decision making, no financial interest in one another, and no jurisdiction over one another. And I think the difference in this case is that there is, very much jurisdiction of one organization over the other.
okay. But I think the board is the key here, because I think there are times where nonprofit organizations actually do, they're created. One is created by the other, and they are intentionally separate, but they're taking direction. I can think of one, where one nonprofit, basically has another nonprofit that is its secretariat, that its staff is doing all the work of this nonprofit because they need somebody. So they're completely taking direction. They do that. That organization may do other things as well, but a third of its work is working for this other nonprofit and serving it. And it was created by this other nonprofit. So that's one piece. And then there may be others who have, and that's where, and these are necessary for a variety of reasons. And sometimes, especially when a nonprofit is made up of government officials, they can't do certain things. So that's why they need another nonprofit to do it. So I don't have answers here, but I think I lean toward the biggest thing is the board and control of the board. If they have if we're going to use for-profits as a parallel, a majority voting shares, if they have a control of the board that's a majority, then, and that may be whether that's control of however we define that. If it's withdrawing or requiring them to be appointed by it, that's control. If they have a control of, it's not just that they're in the same institution, but if they have control of the board, like in nonprofits, that's a majority, then I think that's enough to see it. That's kind of sorry, I'm coming out that kind of thing. Thank you. This has been very helpful.
No,
sorry, go ahead.
I think you raised great points, and I understand as Mr. Winuk was mentioning, that I see the appeal in that a regulation, the idea of creating consistency with, say, 18700.2. But as you point out, the complexities in different relationships between nonprofit organizations can be so complex that the benefit, the major benefit of addressing it in a case-by-case basis is that we are able to take those different factors into consideration. So, I mean, I was just sort of, thinking about different factors that could be considered in the context of a potential regulation. And I wrote down the authority to appoint and remove board members, a majority of board member or shared board members, between the two organizations, whether funding or a certain threshold of funding comes from one to the other, the legal structure, coordinated activities, shared assets. All of these are different criteria that we don't necessarily have to consider, or it's less necessary to consider in the context of a for-profit business because of the greater complexity in the nonprofit context.
And those are all great points. I'd like to shift our conversation back to the specific fact pattern we're looking at here. And I want to make it clear, at least from my perspective, that I think the authority to remove board members is so significant here based on the specific relationship that we're looking at between Stanford University and Stanford Healthcare, not in general the relationship between any two nonprofits or any two persons, right?
Right.
If we had, if there wasn't this authority, but the president of one nonprofit had to be the president of the other nonprofit, and they had authority to take whatever decision they wished to, just based on the fact that there is not authority to appoint a board of that other nonprofit, would not, in my mind, act as a safe harbor, right? Because there's still that direction and control. So once we talk about regulations, I'm interested in sharing some ideas on that, what I think we should consider. But I'm interested in resolving this first issue, and then we can move on to regulation. What were you about to say, Mr. Cornwall?
I wasn't sure if there was a question specifically about the president and their level of control. I might have misunderstood what you're.
No, I provided you with a hypothetical that may be too close to what you're looking at.
Gotcha.
So here's my thought. Currently, and I'd invite counsel for the requester to come up if any of the facts are incorrect that have been presented, or if there's another perspective on our take on this. But it's my understanding that Stanford University, based on what we've heard, has absolute discretion over who gets appointed, who is removed. If that were changed, in my opinion, to provide for a process where a member could be removed for cause, right? Or some other sort of limitation, I think that you wouldn't have that direction or control in this specific circumstance, right? And I'm hoping that, assuming we can get a quorum here to support that we can get to a point where we can get an opinion out that provides that clear direction to the city of Palo Alto as well as Stanford University. So if they feel it's appropriate, they can take action to change their bylaws to address that one specific aspect of it. Go ahead.
Good morning again, Gary Winuk, Kaufman Legal Group. Just a couple of thoughts. First, we're talking about whether a bright line rule applies to for-profit corporations versus nonprofit corporations. And the point's been made that nonprofit corporations are somehow different in that, but I think there are a lot of situations where a for-profit corporation can have relationships that involve direction and control separate and apart and outside of the standard that's articulated. So for example, I think the thought process is having, Pepsi and the subsidiary Pepsi America, and those are giant corporations, but there are many, many, and probably the majority of corporations are small. And so if you have your brother running another corporation that you had him set up, you could be exercising complete direction and control over it. If you have contractual relationships with other for-profit corporations, that could be a form of direction and control. There's a million individual scenarios for-profit corporations where direction and control could be established. I think Commissioner Brandt was getting near that point of saying there's a lot of other circumstances where direction and control could be found where, you may want to apply that rule. But the commission chose, in the case of for-profit corporations, to put in place a more bright line rule so the regulated community can comply with the rule, and have something to look for guidance. I don't think there's that big of a distinction as being made between nonprofits and for-profits. I think there's all kinds of complex relationships between all those entities that can exist. And so nonprofits shouldn't be treated differently by the FPPC. If you're going to have a standard for-profit corporations, then there should be a standard that can be applied, again, for nonprofit corporations. And just getting to the chair's issue, maybe we just have a disagreement here. I understand that, the Stanford University appoints and can remove board members for Stanford Hospital, but Stanford Hospital board members are still exercising independent discretion. And so I think, again, that's been described in a more limited way than I think it is. Yes, they run the day-to-day operations, but they also run a giant healthcare organization. They make strategic decisions. They do all kinds of high-level decision-making for the entity. And I think we're really trying to get at, when Mr. Shikata is making his decisions or participating in decisions for the city of Palo Alto, is the fact that something involves Stanford University really something that is going to impact his wife's employment at Stanford Healthcare? And so I think the theory would have to be that Stanford University would somehow take some action against a board member that somehow would impact, his wife's employment. And I think we're just starting to get really tangential here with how far we're extending, these material financial interests in this case. So I guess I just disagree with the argument that the mere fact that you appoint and remove board members, particularly in this context, should be dispositive. I think it's more complex than that, and I think you're undervaluing the independence that Stanford Healthcare Board can actually exercise and the discretion they have to exercise. Thank you.
Thank you. General Counsel Bainbridge?
Yeah, I just wanted to add, in issuing this letter, certainly this question of this fact that the university controls the board of Stanford Health was a very important fact. But we were looking at this from a holistic perspective of whether treating these two entities as the same serve the purposes of the conflict of interest rules. And I think another factor that hasn't been mentioned that I just would like to point out is that the healthcare exists, as stated in its bylaws, to support, benefit, and further the charitable, scientific, and educational purposes of Stanford University. So I think that's an important fact, too, when you look at the whole of how closely related these two entities are and whether they should be treated as a single financial interest. So just wanted to get on the record that that was also something that we considered important in issuing the letter that we did.
Commissioner Brandt?
So I still come back to, and I hear you about for-profit and nonprofit, and I think it still comes back to me. Simply, if we're going to treat them similarly, then it's about control of the board. So I don't know, General Counsel, whether that's significant that they support, because there are a lot of nonprofits that are created to support other things. So that their objective is different. I don't find that significant, because there are a lot of nonprofits that are created by other nonprofits to support it, but they need to go separately. But the key difference is those nonprofits are often they're separate. Their boards are separate, and they get appointed. The board may, in creation, the one nonprofit may actually create it, be the creator, but the board at some point becomes independent, and the board itself is the one that elects the new members. And that's where I think so I go to, it's about the board, because it's about direction and control. I think that we need to be careful, and maybe we need to do this more broadly in a regulation to consider all these different kinds of factors that I would be happy to be. But I think for today, if we're being asked to reconsider, I don't think Vonnie needs to be reconsidered. That doesn't mean that we can't issue, I don't know, can we issue an opinion like that where we kind of say, this is the significant piece, and if this changes, in other words, can we issue that to Mr. Shikata or to City of Palo Alto? Something saying along those lines, if you give up your control of the board, that will be enough. Can we do that in the meantime while we do regulations at some point in the long run?
Certainly, the commission could issue an opinion that highlights what they find to be the most important factor in this instance.
Commissioner Wilson?
Yes. I've learned more about nonprofits from Commissioner Brandt today, which further highlights the complexity of this issue. I mean, Mr. Winuk clearly outlined the perspective or his advice based on his representation of City Manager Shikata, but it's my understanding that there's also the option of just issuing an opinion that would just relate to this specific case. Would that be correct?
Right. Any commission opinion that the commission would adopt would be limited to these specific facts.
Okay. Yeah, because I have the utmost respect for Mr. Winuk's opinion, but for-profit corporations and nonprofit are different. And the complexities of those differences I would leave to the experts. But I think we should commend the city manager for coming forward and seeking our opinion, and then we should come up with the best solution that directs the FPPC moving forward. Thank you.
Question that might be a bit off topic, but still related. So hypothetically, if you had a public official whose spouse worked for, had a source of income, would that source of income preclude them from participating in a decision that would have a reasonably foreseeable material financial impact on that source of income, where that income is kept separate as part of a separate property agreement? In other words, without being cagey here, could the requester or the subject of this request enter into a separate property agreement that would allow him to continue participating in decisions related to Stanford University, regardless of how we find today?
Yeah, so I'm not well versed in all the complexities of separate property agreements, but under the Act, income is defined for a public official as including their community property interest in their spouse's income. So if hypothetically there was no community property interest in the spouse's income, then they wouldn't have a source of income or source of income interest in their spouse's employer for purposes of the Act.
But I would add to that, they still could have a conflict if there is a connection between the decision and actual a financial effect on that spouse. So in the first scenario, we're talking about a financial effect on the employer, where the separate property agreement may insulate them from there being a financial effect on the official. But if there's a direct financial effect on the spouse, there still could be a conflict for the official.
So it gets into some of the nuances or inside baseball with the Act, but so there's a distinction under the Act's conflict provisions regarding a source of income interest and the personal finances of the official and their immediate family. And so an official who had no source of income interest in their spouse's employer, they would still be disqualified from taking part in a governmental decision if it would affect what we refer to as their personal finances. And so that would be more of a direct effect on the spouse as opposed to impact on the spouse's employer.
And it would have to be reasonably foreseeable.
Right.
Right. Okay. That's helpful. Would you mind walking us through next steps? I know we do not have an opinion in front of us to adopt today. So I assume, we give you direction, legal division prepares an opinion for our consideration that we subsequently approve. As far as the second item, we can give you direction as to whether we're interested as a commission in considering a regulation that addresses the potential ambiguity in this area. Is that right?
Right. Yes. So we could return, if the commission decided that it wanted to go forward with an opinion, we could return at the August commission meeting with a opinion consistent with the commission's direction. That would have to be approved by 3 out of the 4 commission members. And then in terms of a regulatory, the regulatory process, I'm not sure, we would have to look into like potential regulatory calendars and research the issue more. But yeah, we can take direction and go from there in terms of pursuing that.
Okay, that's helpful. Would we take formal action at today's meeting, or we as a commission would provide you all with feedback as to where we're at in terms of reasoning, and then you'd prepare the opinion? In other words, do we need to take a vote on this?
I don't believe so, no.
You don't need to take a vote. I would say I would like to hear a consensus from 3 commissioners that are here in terms of directing us of what you would like the opinion to say. But no formal vote is necessary at this point. That will take place once you have a draft opinion in front of you.
Okay, that's helpful. Commissioner Wilson?
Just for clarification, based on my understanding of local government, I'm pretty clear. But as a city manager, Mr. Shikata would not be voting on any items. That would be done by the council, correct?
Right, so under the Act's conflict provisions, when there is a reasonably foreseeable material financial effect on an economic interest, the official is prohibited from not only making the decision, but participating in making the decision, which includes making recommendations and also using their, essentially using their governmental position to influence the proceeding.
And then in terms of assessing potential conflicts, Stanford Healthcare, if there's a specific decision involving Stanford Healthcare, there could clearly be a conflict. But if there was, let's say, a vote before the city council on whether to build a new arena, that would have nothing to do with Stanford Healthcare. And would that distinction be clearly delineated in any opinion?
Yeah, so under the materiality standards for sources of income, there's essentially two avenues. There's one where the source of income is directly involved in the proceeding, and in general, a public official is going to be disqualified from any governmental decision where their source of income is directly involved. And then when the source of income isn't directly involved, but they may experience an indirect financial effect, then there are separate standards that look at specific monetary thresholds, and we look to determine, is it reasonably foreseeable that this would affect the source of income by X amount of dollars, or this percentage of their annual revenue, or that sort of thing. So that's a much more complex issue, but just in terms of direct involvement, a public official is going to be disqualified when they are when the source of income is directly involved, and then it's a separate issue if there's an indirect financial impact.
Right, that was clear.
Yeah.
So why don't I try this? Why don't I try to state a direction, and I'm going to focus just on today's issue, Stanford, because I think we need to get to. I think there does need to be some regulations about what the lines are. I think that does need to happen. But for the purposes of today's issue, I would suggest that the commission give direction to staff, and it's not a motion at this point because I'm still talking about it. Give direction to staff to draft an opinion that would highlight if Stanford having a control over the appointment or withdrawal, appointment or firing. What? Removal. Thank you. I hate that one. So if Stanford has control over a majority of the Stanford Healthcare Board in its appointment or removal, then that is what the standard is for this purpose. In other words, and there may be continuing other relations, but that means if they could appoint less than a majority and still have influence, but the board is the one who has the authority to appoint the other members that are the majority. So I'd suggest something like that for today's.
Okay, that's helpful. So, like I laid out earlier, I wouldn't personally go that far. So perhaps what makes sense is for us to potentially have two drafts of an opinion. One that lays out a more stricter standard, like Commissioner Brandt has provided, right? With a finding that if there is either authority to appoint or remove a majority of board members, that Stanford Healthcare as well as Stanford University should be treated as one and the same for purposes of the conflict of interest rules. And then a second opinion draft that provides what I laid out, that so long as there is not absolute discretion by Stanford University in the removal of board members, that we find that there's that they are not one and the same. Does that make sense? I want to make sure I laid that out correctly because there was a lot there. Yeah. So for me, the main correct what correct only removal. That's my specific concern is the removal piece, and that there not be and that there isn't any sort of requirement for cause. Go ahead.
So you use the word absolute discretion. So is that over all of them, over some portion of them? I mean, so you're walking away from the majority versus minority. It's like if they have some discretion, so they could remove them for cause or something.
Correct. If you create a process where they could be removed for cause, or they just cannot be removed by Stanford University.
That's a big difference. So that's what I'm trying to get. So you're suggesting. I think I could go with they can't remove that. I think that's a good compromise, that you can't remove them. Not about, because then we get into questions about, well, that's for cause or not. But if they walk away from being able to remove, in other words, they can still appoint. Okay, they can appoint, but they can't remove them because I think that takes away the punishment. If you don't do that, not that this would ever be explicit, right. But the threat that if you don't do this, and we're going to remove a board and remove those members who want to do that kind of thing that your wife is involved in, we're going to remove them and have new members. I could go with that. General Counsel? Sorry.
Commissioner Wilson?
First of all, this is an interesting discussion. I don't know how many people out there can reiterate the different options. So I think before we do anything, it would be beneficial to be very clear and on the record, as stated by perhaps Mr. Cornwall, exactly what direction we're moving in. And then, just from a practical standpoint, would Stanford even consider making these kind of changes? I mean, when you think about any direction we might give them, it's a question. I don't know the answer to it, but they might say, okay, yeah, we'll adopt those recommendations, or they may say, we'll just leave our process the way it is because it's been in existence for, X number of years in accordance with our bylaws.
So let me try to sort of rephrase what I think I've heard here. I think Chair is saying the most important factor for him in determining that these two interests should be treated as the same is the ability to remove members from the hospital board. Whereas Commissioner Brandt feels that it's a little bit broader, that the most important factor is the ability to appoint and remove who is on the hospital board. So I think the two, if you'd like to see two drafts of an opinion, what I'm foreseeing based on what I've heard is one draft that says the appointing and the removing is the major factor in us making our conclusion that these are the same. And then the second draft would say the major factor is the removal. Is that a fair way to summarize?
The only clarification I would make is that my stance is that you would not have to remove the removal authority completely. Creating a process for cause for removal would be sufficient, in my opinion.
So the removal without, the ability to remove without cause is the factor that you
Correct.
consider.
Yeah, that's what I meant by
Determinative.
absolute discretion, but that's a much better way of.
And I think I could live with, you can't remove them. I think that's kind of where I am. So I may be the main difference. In other words, yes, I would like to do appointment and removal, and maybe that's where we go in the long run with this. But in this case, if they're willing to accept giving up the ability to remove, then I'm good with that. I'm not sure. So in other words, maybe there's two opinions. Maybe there's removal for cause is okay, and mine is no removal.
Commissioner Wilson, do you have a take on this specific issue?
I think considering both options is a good one, but also I'm not that up to speed on the bureaucracy of Stanford. Maybe that's why I didn't go there or get accepted, but 50 years ago. But but in all seriousness, I think the relationship between the spouse and the university is important. And I'm not saying we should discuss City Manager Shikada's wife's specific job. I'm not suggesting that at all. But let's say it's, at Stanford Healthcare, you have 1,000 employees. And you have an employee who directly interacts with the board on a regular basis. That would be different than someone who, if they applied for a job, they got the job, and they've been working there for X number of years. So that's, I think, a variable that should be taken into account as well, because while it's not a direct analogy, when it comes to campaign contributions, for example, if your spouse makes a campaign contribution, that isn't necessarily attributed to you, because that spouse is, acting independently. So there's a lot of factors that come into play. I think developing a solution on this specific case is important, but in terms of how we go in terms of any broader regulations, I mean, that could be a major project for your team to take on.
So let me take one more shot at explaining where I'm coming from in terms of the cause piece, right? Sure.
Sorry.
Anything we should know before we move forward?
No, that's all right.
Okay. So what I was gonna say is, I'm gonna go back to a point that Mr. Winuk made, and that's the connection that we're laying out in the decision-making process, right? So we have a third party who could potentially influence this nonprofit's leadership to take an action. That the big word there is potentially.
Yeah.
Right? And in the conflict of interest context, there doesn't actually have to be, that sort of effect, right? I mean, for example, you could have a city council member who actually votes against their interests, right? Maybe they own a bunch of stock in Exxon Mobil and they vote against a lease for Exxon Mobil. That's still, in this very narrow vacuum that we're talking about here, that's still going to be a violation despite the fact that it's not in their personal interest. So what I'm getting at is, we want to make sure that we're addressing appearances of conflicts, appearances of personal benefit, as well as actual personal benefit and conflicts, right? That's what the act asks of us. But we need to be mindful, or at least I think we need to be mindful about how far we extend that reasoning to make sure that these rules are workable. To be clear, I'm not saying that what you're laying out, Commissioner Brandt, isn't reasonable or is an unreasonable extension based on the facts in front of us. But that's where I'm coming from. So perhaps, unless it would cause some sort of burden on the legal division, maybe we come back with 3 different potential ways to characterize our opinion in this matter, right? Highlighting the specific factors that we consider most relevant and persuasive. Does that make sense? Commissioner Brandt?
Do we need to do that for this case? I mean, kind of would like to hear from Mr. Shikata, but I mean, if he's dealing with Stanford University all the time, he may have a sense of where they are. But do we need to? I mean, I'm fine with 3 opinions. If legal staff can get there, I'm fine with 3 opinions. But and I don't know. Yeah, so I'm fine with that, and anyway. And I guess I am interested. I mean, you make some good points. But for this case, I think the key is control of the board and removal. But I think for this case, I don't know whether we need to go that deep at this point. I mean, I think we should also do regulations and set staff on doing a no timeline at some point, not to resolve this issue, but to get it. But is it appropriate for us to ask Mr. Shikata?
That's a question for General Counsel Bainbridge, Executive Director West. I don't specifically see an issue with it. However, what I think is important to highlight is, our legal division, I would assume Mr. Shikata and the City of Palo Alto would agree, engages with requesters on a regular basis in regards to these types of issues in a more private setting. If that's where Mr. Shikata, counsel, would prefer to have these conversations, that would be, I think that might be a better arena, but I'll leave it up to Mr. Shikata. Good morning.
Good morning. Thank you, commissioners. First off, let me say I really appreciate the time that you're devoting to this topic. Quite frankly, it is tremendously uncomfortable and somewhat embarrassing, just the fact that I've brought this topic forward. On the specific issue that you're discussing, one, public discussion versus private, happy to do this publicly, certainly at your discretion. On the topic of the board control, I'm interpreting your discussion as one of trying to define a line that would be useful for you in future decisions and providing that guidance to staff. On the specifics of this situation, I can tell you with some confidence, I actually don't know who's on the Stanford board, but I can tell you that they won't likely consider any changes to bylaws related to this situation, mainly because my position, and certainly not I, are important enough for them to make a change. I would like to perhaps just give you a perspective on the topic and note that on a day-to-day basis, well, certainly the City of Palo Alto is highly attentive to conflict issues, and it's really on that basis that we felt it necessary to bring this topic forward for clear guidance. And as such, to give you a sense of the functional how this plays out at the local government level. First off, to note that the university itself is generally geographically outside of the City of Palo Alto. It's in the unincorporated county. The medical center, on the other hand, is geographically within the City of Palo Alto. Although, as it happens, my wife is employed at the orthopedic clinics, which are everywhere else other than in Palo Alto. So that everywhere from Livermore and Pleasanton to Los Gatos and Redwood City. So just for the purpose of understanding geographically the situation, the typical issues that cross over between the city and the university could be anything from property, and the city or the university does own quite a bit of property within the city, and as such, development for housing, development for university uses are issues that involve both entities and topics like joint projects where we might have a street improvement that are of interest to both the university and the city. And then finally, a large one is the city provides fire protection services to the university under contract. And so in effect, I'm precluded from involvement in any of those discussions. And as your counsel has pointed out, I would not be involved in influencing, providing any input to those topics, which quite frankly are quite a far cry from any involvement of the medical center or much less my wife's employment. So at a practical level, this is quite remote from the types of issues that will ultimately, your decision ultimately affect my ability to engage in. But again, that's not your concern, but did want to make that clear. So with that, I'll just note that the only one person that is more uncomfortable with my bringing this forward than I am would be my wife. So appreciate your sensitivity to that, and also the work that both the commission and your staff has put on this topic. Thank you.
Thank you. Any questions, follow-up questions from commissioners? So just to clarify, so are you saying that the types of decisions that you participate in, that they rarely relate to Stanford University, or the opposite? Because I heard
Really?
remote and
Oh, well, remote in terms of the medical center or the hospital, Stanford Healthcare. So those types of issues are very infrequent.
Okay.
On the other hand, issues involving the university are pretty regular. And as such, this issue does have a significant impact on my ability to perform duties.
Okay, that was my understanding. Thank you.
Thank you.
Do we have any other public comment? Then I would suggest that we approach this by preparing 3 different opinion drafts for us to consider and approve.
Can you clarify what the third opinion, what factors that one would like us to highlight as being the most important in making our determination? I understand the first 2. I don't think I understand the third one.
Sure. So that would be, so why don't we lay out the ones that you do understand, or that you that we have an understanding of, right? So that is, chief factor is any authority to appoint or remove a member of the board,
No.
right? That's number 1.
In other words, no, because I'm backing off of that one and saying, let's do, the 2 are for cause or any control. In other words, I'm kind of willing to say, in this case, control. I mean, I'm not willing to say for cause because I know what that leads to. Then there's litigation over what is cause and that kind of thing. So that's why my sense is that they would give up control over removal only, and I walk away from appointment. So in
Okay,
this
so it
case-
sounds like then 2.
Right.
Okay.
Well,
Why don't we do this? General Counsel, will you lay out what your understanding is? And if it's correct, then we can confirm that. The first one, it sounds like we have a consensus as to what that is.
Okay, I'll give it a try. The most important factor, and I guess before I say that, is this the determinative factor? Okay, so the determinative factor that these should be treated as a single interest is the ability to remove members of the hospital board by the Stanford University board. Right. Okay, and then the second one is the determinative factor is that they can remove members of the hospital board, I guess, without cause.
Sure. Why don't we phrase it this way? So what I'm trying to get at is that they do not have authority to dismiss without cause.
So just to make sure I understand, with cause removal authority versus no removal authority, that is the 2 opinions?
Correct.
Okay.
And then the third one, I missed what that was
I don't
completely.
believe we're considering a third one now. Is that correct?
Right.
Okay. And now we can move on to the regulation piece.
can I also just make a comment? Thank you, Mr. Shikata. I have to say, yes, those are the opinions we want to do because I think that's the reality of it's about board for me. But nevertheless, for these particular situations, like I understand how big Stanford is and how much it's a part of the city of Palo Alto's activities. And so I have some misgivings, but I still think we need to go through this. I have some misgivings about saying, Mr. Shikata, sorry, your wife's going to need to, because if they're never going to accept this, then, your wife may need to move somewhere else. But, I'll leave that. So I have to admit publicly that I have misgivings about this, but I think this is necessary because I think we need to give some clear direction. And I think this is the first start of that. And this is a situation where we have enough facts to identify the problem here. And that's where I think we need to go with it.
Commissioner Wilson.
I'll wait till the draft regulation, not draft regulations, but the follow-up comes forward. But, there's some issues that I think need to be addressed. And you have someone working at the university, but in the healthcare system, which is totally removed from, what's going on in terms of day-to-day operation of, city of Palo Alto. So, we need to, I think, look at all of those issues. I have some other thoughts that I'll keep to myself just in terms of how this can impact a household or a family. So I was.
Okay, and I'll echo, Commissioner Brandt, Commissioner Wilson's comments, thanking Mr. Shikata and council for presenting today. Again, for City of Palo Alto, requesting advice on this topic. So let's move forward to the regulatory piece. I agree. I think we should certainly consider stepping in with a regulation here that lays out perhaps a safe harbor, factors to be considered that ultimately make it easier for the regulated community to identify when the direct or control standard is met. And I think this is going to be particularly complicated because of what we laid out earlier. You got charities, 501c4s, 5s, 6s, etc. So this is not something we're going to want to do on the fly. This is something that we're going to want to solicit a lot of feedback from the regulated community on. Something we're going to want to consider lots of different approaches to. One specific item that I would suggest that we think about is something that was pointed out by Mr. Winuk. This isn't an issue that necessarily comes up quite often in this specific context. I've seen lots of questions in terms of gifts, campaign contributions, not so much in this area. So I'm interested to see if this, based on that, is an area that we should be pursuing a regulation, given that right now we're not getting that many advice requests on it. Perhaps if we were to introduce a regulation that created all sorts of new standards, we would be creating a greater burden and headache for the regulated community. So I'm very interested in that specific piece. Comments from commissioners?
Mr. Wilson, no. Let's do this. I think this is a longer process, so I don't know how long. I think there are all these things to consider. I would really appreciate, there are the Association of Nonprofits. There are a number of entities that may be not normally in our world. Yes, the regulated community that we deal with all the time, they need to be front and center. But at the same time, there may be others who may be able to contribute to this conversation about because it goes to the what nonprofits are, and do we need to? I'm not. Part of this is considering, do we need to, and I think you raised some good questions, do we need to apply this kind of issue more broadly? Are there other situations? And sometimes the law provides exemptions for 501c3s. And so maybe not. But anyway, this is a long process. I'll affirm that the complicated nature of this, and I want to engage as many as we can who may be interested in this.
Commissioner Wilson.
Commissioner Brandt clearly outlined some of the options, but at some point, and we'll seek advice from our general counsel, at what point, if we begin to adopt regulations relative to nonprofits, at what point do we move beyond our regulatory authority under the Act and move into the arena where any additional policies would have to be addressed through legislation?
So I think this direction is going to be far more clear for you. I think, commissioners, it's my understanding that we are asking the legal division to explore developing a regulation that interprets when direction or control is exerted by one entity over another in the nonprofit context, for purposes of the conflict of interest rules. Any thoughts or further direction on that piece? Okay, any public comment? Okay, hearing and seeing none, let's move on to item number 10. And we're going to welcome Senior Commission Counsel Zachary Norton to the table here to discuss a pre-notice discussion of proposed amendments to regulations 18401, 18421.3, and 18430.1. Good morning, Mr. Norton.
Good morning, Chair Silver and Commissioners. So today's amendments for pre-notice discussion concerned two different issues. They're both related, and these are both issues that were brought to our attention by the Enforcement Division's special investigators who discovered these issues as part of investigative work they were doing in cases. So issue number one concerns strengthening the requirements for contributor verification by vendors who collect online contributions on behalf of candidates or committees. And this was brought to our attention when enforcement investigators identified instances where there were contributions that appeared to have been made, multiple contributions made through the same credit card, but attributed to different contributors. And the second issue concerns the use of prepaid cards for making both contributions and expenditures. And this was also brought to our attention by enforcement special investigators who found instances where it appeared candidates and committees had given prepaid cards in fairly large amounts of several $100s to committee staff for the purpose of then making committee expenditures which were outside of the campaign bank account. And due to the nature of prepaid cards, they are not traceable, there's no paper record, and it also doesn't comply with the one bank account rule. So we'll begin looking at the online contribution regulations. So the Act does permit candidates and committees to raise funds over the internet, and this is typically done through these contract vendors or collection agents. And this is permissible so long as record keeping and disclosure requirements are complied with. And how this will typically work for practical purposes, the contract vendor, which would be something like ActBlue or WinRed, and there are some others as well. They sort of facilitate the online contributions. They can help set up a portal on a candidate's webpage, for example. When you're looking at the candidate, there's a section that says you can contribute here. They sort of facilitate that. And as a part of what they do is they not only collect the funds, and in doing so, they use an outside payment processor because they themselves are not financial institutions. The payment information is run through a third-party processor. But these payment platforms collect contributor information, and they turn that over along with the funds to the candidate or committee. So the vendors do take some steps to help verify these transactions. They utilize technology to track the IP address, Internet Protocol address, to make sure that the contributors are present in the United States. They do take other steps to help tried to verify the identity of the people making contributions so that you're not just relying on information on payment gets input into the system. They provide the name, address, occupation, employer, and we're just sort of taking their word for it that it's good. We want additional steps to to check to make sure, was this really this person's credit card? So.
And Mr. Norton, sorry
Yes,
to interrupt you. So some of these measures that they take are required by law, others are not, currently,
Yes.
under the act. So address verification, we don't currently require that.
No, and that's kind of my next step is I sort of to take a step back, around the time the act was passed in 74, there's statistics at that time show that roughly, I think 86% of non-cash transactions occurred by check, significant number. More recent data shows that almost half of Americans did not write a check within the past year. So we have definitely shifted from checks are kind of the dominant form of non-cash transactions to a very new world of cashless, paperless payments. So I think as we've moved from the more traditional check form at the time of the act, what we want to do is, now that we're going towards digital payments, is to require, as you've kind of pointed out, these industry standard additional verification measures. And a part of that we believe will be effective is this address verification system, which it's an independent check that just compares whatever information they've provided with the cardholder information at the bank. And that can be very simple. For example, if you've ever purchased gas where you're using your card at the gas station at the machine, it might ask you to enter your zip code. That's a very rudimentary form of address verification, just to make sure that, all right, if the person using the card can enter the zip code affiliated with the card, that sort of verifies that this person is the card holder. That can go a little bit further, and that's what we want to do, is require the better industry standard where it also compares the street number and also checks the verification code, which is the 3-digit code on the back of the card. And we do realize that there are some limitations. I reached out to staff with Act Blue. I contacted staff, to the people that started one of these local companies, talked to them. I did reach out to WinRed and PayPal as well. I tried to do broad outreach. I didn't necessarily hear back from everyone, but from the people I was able to talk to, they said that we can't go so far as to obtain cardholder information, or the cardholder name, through the ABS. That's just not available to them. That would have been ideally what we would have wanted. It's not practical, but what we are proposing is to require this sort of, what we feel is probably the gold standard of verification by using ABS. And I think that goes to the problem that we identified, our enforcement investigators identified, where it did appear that you had one card that was used for 3 or 4 different contributions. Clearly that's a problem. Now we don't really know who was making the contributions, since they were all tied to one card, but we knew that that was a problem that we think greater identification would help flag, to help preempt. And I will point out that the payment processors are looking for these things. They're not trying to turn a blind eye and assume whatever comes in, sure, we'll take the money, we'll hand it over, it's not our problem. They do want to flag for these things from the conversations I've had. So I think making sure that stringent measures are in place helps to protect against the problems that enforcement staff has identified.
Well, that's really helpful and great work on this. Speaking of a complex issue, another very complex issue that we're dealing with here.
Yes.
And also want to thank enforcement staff for flagging this. This is a very serious issue. It could lead to making it easier for potential campaign money laundering, which is one of the most serious violations of the Political Reform Act. So I'm glad we got this on the regulatory calendar, and I'm glad that we have hardworking investigators and attorneys in the enforcement division who are willing to go above and beyond, identify this issue, write a memo on it, and provide it to the legal division.
Yes.
So I want to thank them. I think one thing that I'd like to point out is while these payment processors, some of them, may be already doing some of the measures that we are looking to require here, they're not currently required by law to do so, so they're doing it by their internal policies, and technically they could decide tomorrow, well, we don't want to do address verification anymore.
Yes.
And that's a concern of mine because it seems like, based on my review of the facts here, that these sorts of policies are relatively new, right? So I'm worried that in the future, some of these entities could decide, well, this isn't as much of an issue for us anymore. Let's just drop our address verification service, or any of the other requirements that we're placing on today. So I think this is very important, despite the fact that some of these practices are already adopted in this arena. One additional suggestion, I think, given our focus on potential illegal contributions from foreign entities, I would suggest that we include in this regulation a prohibition on the making of contributions, or I should say processing of contributions, through these third payment processors through foreign IP addresses. It sounds like some of the TPPs, the payment processors, already take this approach for that very reason, that concern of foreign entities illegally contributing in elections, as that is prohibited under federal and state law in certain circumstances. That would be my recommendation at pre-notice. I'm interested to see if fellow commissioners have any thoughts or comments on that additional prohibition. No? Good idea. Thank you. Mr. Norton, any general thoughts on the implications of doing that? I know you touched on it a bit in your memo.
Yes, and that is something we looked at, and that is something right now that the vendors are flagging for that, and I had a conversation about that, and they said that it does come up sometimes, that there's some issue that, this is a foreign IP address. They'll actually contact the contributor if it seems to warrant further investigation, is inherently suspicious, and they say, it's someone who's on vacation. They have a place in Mexico and they're out of the country at the time, but they're still eligible to make a contribution, so they will go ahead and authorize that. I think our only concern would be that it is more and more common that people are using VPNs, which mask your IP and would make it appear that you are somewhere else, which I think could complicate things. It might actually, I'm worried at one part it might give sort of a false sense of security. We check for this, we make sure we block everything. It might also prohibit some people in those situations who are out of the country at the time from making a contribution. And it may also complicate the ability to actually validate their geographic location using that if they're using a VPN, because many of the more complex ones also are very good at sort of, spoofing your GPS to hide your actual location.
And that makes sense to me. And I feel like a constant struggle the FPPC is dealing with is that bad actors are going to attempt to avoid the roadblocks that we put in front of them, right? I don't think that necessarily, in of itself is justification for not taking a step that could create that additional hurdle for a bad actor.
But I would also, could I just point out that I've done some research on VPNs as well, and it's not just bad actors that are using them. It's not just something you use it. I mean, I guess there's a variety of reasons. Some people use it because you can watch content through a streaming service out of network. Mm-hmm. In other places, people use them because they're in a geographic location where actually news and certain media services are totally unavailable. But apparently there's also a privacy issue. I read recently that about 30% of internet users are now using VPNs. I've looked into it, and I guess there's certain reasons if you're doing online banking, trading stocks, there's actually privacy reasons for you to want to use VPN because it actually protects your data as a consumer. So it's not just that, there's a small subset of these bad actors that might, I'm going to go use a VPN to try to do something I shouldn't otherwise be doing. It seems that they're more and more common. So I think that's just something to keep in mind.
Yeah, I would just add, I think this is something we want to look at, because if we're going to be prohibiting a means by which people can make campaign contributions, we should tread lightly and make sure that that prohibition would be effective in accomplishing the purpose that you're suggesting. So if it's okay with you, I think we'd like to research this issue, look at it more closely, and then if we think it's something that is a good idea and is permissible, we'll bring it back at adoption.
That's a great point. That absolutely, works for me.
Yeah,
Commissioner Grant?
I want to affirm that. That's a great idea because I am actually required. I get IT through the University of Nevada, Reno. I work remotely in Davis. So in order for me to get online I have to have my VPN, their VPN active all the time to be able to get into the files at UNR. So that's on my computer. So everything I'm doing, even when I'm not in the files, I have to be on the VPN. So that's why, it's a more and more a standard.
And just to clarify my opinion on this, I would not suggest that we prohibit contributions, the processing contributions made through a VPN, right? My concern is the foreign IPs, and I see what you're saying in terms of the VPN allowing for circumvention of that type of monitoring, where you can identify a foreign IP and then prohibit that that payment. So that totally makes sense to me.
Yes, but we couldn't, I think just to kind of reiterate, we couldn't prohibit contributions made through a VPN because they don't know the VPN's being used. They're just seeing a geographic location, which, as Commissioner Brandt noted, it on there, and they might just see, oh, that this user is in Reno, Nevada, and that allows certain access. So I think the VPN is basically masking the true location of that user. And apparently they're hard to detect. I think from what I've read about when they're used, and people in other countries use them to try to access content where news is limited.
Right.
They're not really detectable for the most part. So even though they're technically illegal in some countries, people still use them and are able to access sort of the greater world of the internet by using them. And it's not necessarily apparent that that's happening. But I agree with you. Definitely that we do need to tighten up regulations on this. While there's evidence that yes, they are the entities that are collecting contributions are using things like AVS. We do want to make sure that this is enshrined within the statute. It's important that they keep doing it. I think there are costs associated with doing it, so we would want to make sure that we don't have others popping up and saying, it'd be a little bit easier and cheaper if we did it this way, because I think the goal of the act is to ensure transparency and disclosure. It's not necessarily to make things the easiest and cheapest way to do it. If that were the case, we would say, sure, take cash. If you've got cash on you, we don't need a check. But we impose sort of minimal regulatory standards regarding these to just make sure that the information is there. And I think this is a step in the right direction.
Absolutely. One question that I don't know if you can answer this right now, but it'd be helpful to know when we're considering adoption is whether other jurisdictions have adopted the sorts of requirements on third payment processors that we initially sought, that we were told by third payment processors weren't possible. I assume the answer is no, because it's not possible, but you never know.
Yes.
Do you have an answer to that question right now, or is this
That's something I did look at a little bit. I could not find anything. I think we're sort of ahead of everyone else on this issue from what I can tell, unless something's changed very recently, but no.
Excellent. Okay, well, thank you for that. Any other comments or questions from commissioners? Any public comment on this item? Hearing and seeing none, as this is a pre-note.
I did. There's issue 2, the prepaid cards, which I can just touch on briefly.
Sure, go ahead.
If we would like, and that's basically that enforcement also discovered that these prepaid cards are being used kind of as a circumvention to the one bank account. And these can be as simple as you go to the grocery store and you buy a $500 prepaid Visa card that works just as a credit card or bank card. It's just not tied to anything. So in that instance, there was no real record of campaign expenditures. I think they were able to kind of piece it together with receipts and found out that, yes, they were making significant expenditures. So Part of it would be to, since these things spend like cash, is just to treat them like cash. And the same for contributions by prepaid cards. I did speak to the operators of one of these sites. They said those are very easy to spot, and they're problematic as well because they realize that they're not tied to anything. I think it's based on the card number. So there are no technical limitations if we were to limit the use of prepaid cards for contributions of $100 or more, either through these online vendors, because they are easily identified and they could be flagged and rejected, which I believe ActBlue is now doing for contributions at any amount. So that's kind of just the second half.
Oh, that's helpful. Okay, and I'd suggest trying to get a hold of somebody at WinRed before we move for adoption. It would just be helpful to hear their perspective, since it sounds like they're one of the other major players in this area. Obviously, you've
Yes.
already reached out to them. We can't force them to respond, but maybe just another communication in the meantime.
Yes, I would appreciate that. I sent both ActBlue and WinRed the same email at the same time, basically explaining who I was and what my project is. And I have not heard back, but I would appreciate any additional feedback that they or any other processor would like to offer. So,
Excellent.
Thank you.
Thank you. Any public comment? Hearing and seeing none. Thank you, Mr. Norton.
thank you.
Why don't we move on to item 11, and that's going to be Public Outreach and Technology Committee update. I'm going to welcome up to the table our executive fellow, Eva Hartman. Good afternoon.
Good afternoon. My name is Eva Hartman, and I'm the State of California Capital Executive Fellow, placed with the Fair Political Practices Commission this year. A significant portion of my work at the Commission has been devoted to organizing a series of panels on effectively leveraging and regulating artificial intelligence in the political process, the first of which was held by the Technology and Public Policy Committee on April 22nd. This panel, titled Detecting AI in Campaign Advertisements, focused on finding solutions for the implementation of AB 2355, a bill passed in 2024 which requires that political campaign advertisements which use artificial intelligence to generate or modify images, audio, and video disclose that information during the ad. The FPPC has been tasked with enforcing these disclosures and currently faces the challenge of accurately evaluating political advertisements for signs of AI use. This technological challenge is shared by governmental ethics agencies across the country who are also confronting the rise of artificial intelligence use in their elections. This panel featured presentations by Dr. James F. O'Brien, Professor of Computer Science at the University of California, Berkeley, Kevin Guo, the CEO of Hive AI, and Katie Brooke and Andrew Kabak, representatives of Adobe. Dr. O'Brien argued that AI detection technology will not be able to match the pace of AI innovation. Mr. Guo advocated for his company's product as a method of AI detection that will continue to work effectively regardless of AI's advancements. Ms. Brooke and Mr. Kabak presented an alternative solution via a new technology called content credentials, which store information about an image's generation and alteration within the image code. Our team's takeaways from these presentations are as follows. 1. The use of artificial intelligence to generate and alter images, video, and audio will continue to evolve and become more difficult to detect. Whether detection methods and tools will advance quickly enough to enable the FPPC to accurately identify AI-generated or modified content remains uncertain. 2. The FPPC is unlikely to find a method or tool that guarantees perfect detection accuracy. Regardless of what future action is taken, the FPPC will need to incorporate human investigation into case inquiries. 3. A comprehensive legislative solution defining how AI-generated content should be labeled may help resolve some identification issues for the public, but would leave open the question of enforcement of such a law. The legislature's openness to, and the legality of, adopting mandatory content credentials should be studied. Our next panel, which will focus on the safe and effective implementation of AI tools within ethics agencies, will be held in August. Thank you to Chair Silver and Executive Director West for their mentorship, and to Commission Assistant Davina Vo for her help on this project. I'm happy to answer any questions.
Excellent. Thank you for your hard work on this. We really appreciate it. And just another indicator of what an excellent program the Capital Fellows program is.
With two of us
We have three?
being,
No, I believe we have.
you were a fellow? So all three of us were fellows. Yes.
Yeah.
Okay.
And
And what you have to look forward to?
I'm in good company.
But also for those who are interested in the fellowship program, and I say this in all seriousness, the program initially was just the Assembly and the Senate programs, and then it was later expanded to include the executive and judicial fellows. And it went from 12 to 18 fellows per program back in the 90s. So thank you for your excellent presentation.
quick question for you. If a member of the public wanted to watch the proceeding, are they able to do that?
Yeah, it's on the FPPC YouTube page.
Excellent. Okay, great. Well, I think it's excellent that we were able to get all this feedback from the regulated community so quickly on a relatively new, complex issue related to technology. So thank you to you. Thank you to the participants who provided us with this feedback. And I'd also like to thank the additional individuals and entities that have since reached out to us and provided us with feedback related to this specific issue. And I'm looking forward to our next hearing in August. Any other comments or questions from commissioners?
Well, I would just say it was an excellent presentation. You know, I was there to hear the presentation. It was very informative. And to anyone who wants more detail, I think that going back and looking at that video would be very informative.
Thank you.
Excellent. Any public comment? Okay, hearing and seeing none, you're all done. There you go. Let's move on to item number 12, and that's going to be our legislative updates. We're going to welcome up to the table Senior FPPC Legislative Counsel Lindsay Nakano. Good afternoon, Ms. Nakano.
Hello, Lindsay Nakano, Senior Legislative Counsel for the FPPC. All right. There are 13 PRA-related bills that were passed in the House of Origin and are currently active in the legislature, including all 8 commission-sponsored bills. 7 of the 8 commission-sponsored bills have been set for hearing in the elections committees. The hearings are July 1st for the Senate Elections Committee hearing and July 2nd for the Assembly Elections Committee hearing. The 8th bill, AB 808, which makes cleanup and conforming changes in the PRA relating to the Cal Access replacement system, is expected to be set for a later hearing. We also expect forthcoming amendments to that bill to make additional conforming changes to the PRA. Our legal division worked extensively to comb through the act to identify other conforming changes that needed to be made to ensure that the that statute is consistent with the requirements for the development of cars. And we worked closely with the Secretary of State's office to ensure that they are also in agreement with those changes. One additional update on commission-sponsored bills, SB 852, the Senate Elections Committee bill that eliminates the manual notification requirement for amendments of PRA bills, was amended on Tuesday to make a correction. For context, last year, the commission-sponsored bill, AB 1170, was signed into law. That bill required the filing of certain statements of economic interests, also known as Form 700s, through the Commission's electronic filing system. The intent of the bill was to apply this electronic filing requirement to all of the officials listed in Section 87-200, and that includes higher level officials. But one category of officials was inadvertently left off of that list in AB 1170. That category was public officials who make manage public investments, rather. The recent amendments to AB 808, what bill am I on? SB 852, corrects that omission and make another change in the government code unrelated to the PRA or the FPPC. So I'll pause here for any questions about commission-sponsored bills. Otherwise, after that, I'll move on to commission-related bills.
Commissioners? No questions from me either.
Okay. There are 5 other commission-related bills still moving through the legislature. 3 of those have been set for the July 1st or 2nd Elections Committee hearings. Those are AB 950 relating to campaign advertisement disclaimers, SB 42 relating to public campaign financing, and SB 760 relating to behested payments that are made through a public appeal. SB 42 was amended last month to add co-authors, but there have been otherwise no other amendments since the last commission meeting. That concludes my update today, but happy to take any questions.
Any public comment on this item? Okay, excellent. Well, thank you,
Thank
Mr.
you.
Gano. Let's move on to our next item, and that's going to be our executive staff report. And we're going to start with our assistant chiefs, Angela Brereton and Chris Burton. Welcome back.
Thank you. This month, the Enforcement Division report is as submitted, but happy to answer any questions that you might have.
I don't have any questions, just a comment, and this is, again, a compliment for both your division as well as the legal division. In terms of the legal division's executive staff report, it lays out all the probable cause proceedings that recently occurred. It's significant in my experience to have this many. It looks like 1, 2, 3, 4, 5, 6 different probable cause hearings on this report. It's very impressive. I know the level of time that it takes and work to get this all together. So from this commissioner, thank you to staff for keeping these cases moving forward through the process so diligently.
Thank you for noting that.
Yeah, I would second those comments.
Any other questions or comments from commissioners? Okay, any public comment on this report? It doesn't look like we have any. Thank you, Mr. Burton. Ms.
Thank you.
Burton. I'm going to move on to the next report, and that is going to be from our Audits and Assistance Division. And today we're going to be hearing from Gabby Gilmore, who is relatively new to the commission. She's a senior management auditor, and she'll be presenting while our division chief, Sharada Shah, is out of the office. Good afternoon.
Good afternoon. The Audits and Assistance Division report is as submitted.
Thank you. Any questions from commissioners, comments? No? Great. Any public comment? Hearing and seeing none? Thank you, Ms. Gilmore. Okay, let's move on to the Legal Division, General Counsel Dave Bainbridge.
Nothing to add from what's in the report, but we'll happy to take any questions.
Okay, nothing to add on my part.
Nothing.
Okay. Hearing and seeing no public comment, why don't we move on to our next executive staff report. We'll be hearing from the chief of our administrative, or I should say Administration Technology Division, Dr. Ju Wang. Good afternoon, Dr. Wang. I know you do have some items that you'd like to highlight, so we can go through those.
Yes. First, my report submitted as it is, but I do have a couple of things I would like highlighted. So all the 87-200 statement filed with Commission on or after January 1st, 2025, currently available on FPPC website. So if there's any statement filed with FPPC and the public cannot find it, feel free to reach out our SEI unit. We're happy to help the public to find the statement. But currently, all the 87-200 statement available on our website.
That's an important update. And just to give the public some additional background on that, previously we had only posted the Form 700s for elected officials who file with our agency, correct? And then at the urging of local jurisdictions across California, we decided to expand that to all 87-200 filers that file with our agency, and now they are posted on our website.
Yes, we have the newly adopted regulation 18313.5. So from now on, all the 87-200 statement will be available on the website.
Well, we really appreciate the quick turnaround on that. I met with officials from County of Ventura, County of Los Angeles, and that was something that they emphasized, that they appreciated that we were expanding the available data online and increasing transparency for the people of California.
Yeah.
Sorry to interrupt you. You can go on.
Yeah, and we're kind of wrap up for the 2024 filing season. So we are learn a lot from the first year mandate e-filing. So we're gonna continue work with filing official to create more fact sheet to make sure we have another successful year. Last thing I want to update is our hiring process for our enforcement chief. So we make a lot of progress for the hiring. So the first round interview will be scheduled in the first week of July. So hopefully we will have the enforcement chief join us very soon. And that's all my highlights, and I'm happy to answer all the questions you have.
The only other item I wanted to highlight is I wanted to welcome a new attorney to our legal division. And that's Mo Raquel Navazio. She's waving to me, wave right back. Thank you. Thanks for joining us today at the meeting and welcome to the FPPC. We're also, as Dr. Wang referred to, we're still in the process of seeking an enforcement division chief. And there's 2 open positions in the legal division, right? This might be a typo, I don't know. Is there still an attorney position open in the legal division? Okay, there's not a typo. Okay, so we still have 2 positions open in the legal division, an attorney and a political reform consultant.
Yeah.
Excellent. Any other comments or questions from commissioners? No? Okay.
Thank you.
Thank you. Let's move on to our executive director, Galena West, for her update. Good afternoon.
Hello, don't have much today. That attorney position, the only thing I would note is we want to say goodbye to Jack Woodside, who's retired, who was one of our senior attorneys in the legal division, and he'll be sorely missed. He was our expert on 1090. People went to him for advice, and he was a great presence in the legal division, vast knowledge, and he will be missed by the agency, but we wish him all the best.
I agree. Excellent attorney, excellent person, served as a mentor to so many of us at the FPPC. It's a huge loss, but I'm glad for Jack that he has a lot more free time now. Go ahead.
So he's already retired? I mean, and I just think for the benefit of the record, not to put you on the spot for the exact number of years, but to the extent that can be entered into the record to reflect his long tenure and dedication to the FPPC.
Let's see. I think it's about 12. I think he's been with the agency 12 years.
Yeah, that's great. Thank you.
Yeah, and even before that, he served the people of California with the Attorney General's office in their government unit, advising on these same issues. So he's truly an expert and public servant. Any general public comment on item 13 that hasn't been addressed? Hearing and seeing none, let's move on to item number 14, which is going to be commissioner comments, proposed future agenda items. I have nothing to add. Is there anything commissioners like to add? Doesn't look like there is. Public comment. Hearing and seeing none, I'm going to move to adjourn.
Second.
Ms. Vo?
Commissioner Brandt?
Aye.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Meeting adjourned.
Thank you.